Hey everybody, we're about to get started. Here's the opening music. Hope you enjoy the show today.
The situation is unique. You should contact your attorney before taking any legal action
That's good
related
advice.
to the subjects discussed in this program. Welcome to Aging Insight, the only show dedicated to your elder care concerns and your resource for learning about how to manage your health, housing, financial, and legal needs. This is a live call-in program featuring John Ross and Lisa Schulmeyer, elder law attorneys and senior advocates for the Art Latex. Aging Insight is dedicated to helping you navigate the challenges and blessing of growing older. So call in and ask your questions. The number is 903-793-1071. Now here are your hosts, John Ross and Lisa Schulmeyer.
Welcome to Aging Insight, everybody. This is your host, John Ross, here live in the studio with my faithful co-host, Lisa Schulmeyer, who can't get her microphone in the right place.
No, I'm getting there. Okay, maybe this is it.
But now she's here, and so you're listening to Aging Insight here right at the end of 2018.
Where did it go?
Yeah, the last edition of Aging Insight for 2018, and you're getting to listen to it.
Yeah, well, I still can't figure it out. Just flies by.
Yeah, no, it just keeps going every year. But it's better than the alternative.
That's right. That's right.
And of course, we're live here in the studio today. We're also live on Facebook. So if you got a chance, get on the internets there and check us out on Facebook. Go to the Ross and Schulmeyer Facebook page or Aging Insight, or you can come to my personal page. One way or the other, you can see us. You can share the video if you think is good. You can also comment on there. You can also, if you're listening on the radio, you can give us a call. Phone number is 903-793-1071. If you've got a question that's just burning a hole in you and you just got to get it out, got to get an answer to it, we'll be here to answer it. And of course, our program is brought to you by our sponsors, Dirksen Memorial Hospice, Edgewood Manor, the Barnett Agency, Cowhorn Creek Estates, Texarkana Funeral Home, Red River Federal Credit Union, Reunion Plaza, and Heritage Plaza.
Yeah,
so
that's right. And so those sponsors, we appreciate them because getting on the radio and talking to the people and educating and hopefully entertaining you, it's not a free thing to do. So it's great that our sponsors are out there to help us get this information out there, get you entertained, be a friendly voice on the radio for you.
That's right.
So.
And we didn't really have a big heavy intellectual topic for you today. Instead, we kind of thought maybe we would just tell a few little stories, some of the things that we've come across on the internet, some of the things that have happened in our own personal clients, some of the odder things that people have asked of us, and some of the dumb things that people have done.
Yeah. Yeah, no, unfortunately, good stories, John, and good entertaining situations at, sadly, other people's expense, that usually doesn't come from, doing everything right and businesslike and,
No,
the lessons, if you will, come from, other people's poor choices, judgment. Sometimes they thought they were doing the right thing. It didn't turn out that way. But so we thought we'd just kind of share some of those today.
Yeah, so that was kind of the plan, and I had actually come across a website that had some other attorneys and stuff where they had posted some of the things that they had seen, and we thought we might share a few of those as well.
Okay, but the funny thing about John, you sent me that article about the craziest things lawyers have ever seen and wills, and going through and there was umpteen.
Yeah, there's a bunch of them.
Yeah. We have seen a number of those in our very own practice.
Oh, yeah, absolutely.
So the whole internet, the whole world was asked to contribute to this article.
And we could have contributed most of it.
Right. So
just out of our own.
So, yeah, anyway.
But, that's one thing of dealing with a lot of people on a day-to-day basis. And and so anyway, we'll just kind of jump on in. What do you want to start with?
Let's start with the pets. Pet stuff.
You do get lots of stories with the pet stuff.
We've talked before about, Leona Helmsley leaving, all that money to her Bichon or Maltese or whatever that little frou-frou dog was. And And it's not an unusual thing for people to be very attached to their pets and realize that as they've gotten older that their pet might very well outlive them. And so it is not uncommon at all for people to come into our office and ask to be planning for some pets. And so we have done that numerous times, of leaving funds aside to care for animals, dogs, cats, birds, horses, a donkey. I've had a donkey, but so that's pretty typical.
It's not uncommon for those sort of things to be requested. What a lot of people don't necessarily understand is, to them, that dog, iguana, donkey, whatever it is, that's a member of their family.
Right. But to the law, it's just a piece of property, kind of like your couch.
Right.
And you cannot leave money to your couch. Now, I don't know if you dip between the cushions, maybe your couch already has some money.
Yeah.
I don't know.
Couch may be richer than you are. You don't know.
But so you can't leave property to other property. So you do have to set this up properly. And one of the stories, I don't think I've ever had this, was that a lawyer set up a will where $1 million was left to a horse.
Yeah, and I guess it's being managed in a trust,
Yes.
and then a couple of percent comes out every year for the care and maintenance and upkeep.
Right, of the horse. And I know horses are expensive. I refer to horses as money pits. I have never had the pleasure of owning one myself. I'm pretty sure I'm too cheap and too practical to actually own a horse, aside from the fact I'm not really a big fan of their personalities as a general rule.
Yeah.
But and then of course, John, we had the case where the lady left $25,000 straight out to her Cocker Spaniel.
50.
Oh, that's right. It was 50.
Yes, it was $50,000.
The court ended up cutting it down to 25.
$50,000 to the Cocker Spaniel, or technically, in this case, it was to a neighbor
for the
care and maintenance of the Cocker Spaniel. And man, did that turn into a nightmare.
Yeah, because where there is money, there's a fight. Kind of like where there's smoke, there's fire.
Yeah.
And so when you have $50,000 left to a dog in our community, there's likely to be a fight of children who feel like they should have been left $50,000 and not the Cocker Spaniel.
Yeah, and so yeah, if you do want to provide for your animals, it does have to be done very specifically. And like in this case, it's not just as simple as hey, here's $50,000.
Take care of my dog.
Take care of the dog, but what does take care of the dog mean?
Yeah. Do you get to take the dog on vacations?
Right.
That you get to accompany the dog on, because the dog really wants to take an Alaskan cruise.
That's exactly right. And so you run into all kinds of problems of does the person get paid to board the dog, and do you take the dog on vacations, and is that an appropriate expense? And of course, what happens to the money if the dog dies?
Yeah. So does the caregiver neighbor get to keep the money, or does the money go? Where does it go?
Yeah, and this can get into interpretation of your will.
I think interpreting is
interpretating,
okay.
Yeah, in this case. And let me just anytime you start talking about needing to interpret the will,
cha-ching.
Yeah, that's just going to cost a whole bunch of money.
We need to get some sound effects. We need to up our game here.
Yeah, we do.
So we can always ring the cash register bell or something.
That would be awesome. But you got to watch out for taking care of the dogs. And of course, you had one where basically the person didn't think anybody would ever take care of the dogs.
Right. So I had a client, and she had a couple of beloved animals, small dogs. And she came into the office and would like to do some will. And she talked about her animals. They were clearly so precious to her. And she said, if I die and leave my animals behind, then I want my animals euthanized shortly after my death.
Yeah.
And I want my animals buried with me. I don't remember if it was cremated, but whatnot. She was, and I asked her, I thought, well, gosh, that's a little harsh, or what's your purpose? Why? And her response was she was completely convinced that no one else, not a family member, not a friend, no one would care for her animals as she had, with the level of attention and pampering that she had provided these animals. And she said, I cannot bear the thought that my animals could suffer after I'm gone, where they wouldn't be beloved and loved, or are they turned over to the pound, or, to the rescue or whatnot. And she said, I just can't bear that thought. And so therefore, I want these animals cremated or put down at my death. And again, John, these animals, while they are living creatures, they are in fact considered property.
Yep.
And, if this lady said, donate all my furniture to Goodwill, and she said that in her will, that's perfectly appropriate.
Yeah.
I've had a client who donated her old house to the volunteer fire department to burn it down.
Yeah.
For training purposes.
And so yeah, animals are property. And so, yeah, a bequest of euthanize the animals it's actually perfectly legal.
It's perfectly legal. Now, I know some of you listeners are out there probably horrified. And it is legal, but you know what, John, when the client passes on and her will is probated, it would be the responsibility of her executor to carry out the wishes to euthanize the animals.
Yep.
And I highly doubt the executor will carry that particular provision out, which would be a violation of their fiduciary duty.
Yeah.
However, who is going to seek to enforce this fiduciary duty to put down the animal?
Yeah, I don't think anybody would really, and it's certainly not enough to spend the money to try to contest.
Right. So, and even if there was someone out there that was willing to say, hey, Bobby Joe, you didn't put down, Sue's animals, so therefore, you're in violation of your fiduciary duty. I don't really think a judge would be all that upset about it either.
Yeah, no, probably not.
I kind of viewed that as, yes, the lady in question, she perfectly had the right to request that her animals be put down. And should the executor follow her wishes, there's no harm, there's no damages to that anyone else could claim if that executor carried the wishes out. If the executor chose not to carry those particular wishes out, I don't think there's going to be anyone to complain about it. And I don't think a judge is really going to punish the executor for not doing so.
Yeah, it wouldn't seem like it. And
Yeah.
And this was actually a very similar in the list of odd stories on this
From the internet.
There was one very similar where a lady wanted to have her cats cremated at her death.
Yeah.
But in her case, she actually wanted to be cremated with the cats.
Yeah, well, apparently, and I'm not big on all the legal rules and regulations concerning cremation.
Yeah, we should have called our sponsor, Texas County Funeral Home, and asked them the question.
Well, yeah, maybe we'll follow up with that. But yeah, apparently, you cannot cremate humans and animals in the same event.
Which, if that is actually a rule, is prime example of stupid rules.
Well, I don't know. I mean, you don't want to, if you're a cremation, you don't want to think that, I don't know, it's a little weird to think maybe there were animals or, cremated at the same time. And
it's all getting burned up.
I know, but it's for the living, John. It's for the living.
Maybe so.
But yeah, in that particular case where the lady wanted to be cremated, with her cats put down and all cremated at the same time, that was not going to work. But they could be cremated separately. The cats could be put down.
Yeah.
The human and the cats be cremated separately.
And then all combined.
And then their ashes mixed together. So that will work ultimately.
Yeah. And I did actually have a different client who, although did not want any of her current animals to be harmed or euthanized, she had kept the cremated remains of her past animals, and she did want all of her cremated remains mixed with her past animals' cremated remains and all buried together. So I have had that request.
Well, okay.
Not ending the lives of any existing ones, but certainly mixing the ashes with those of the others. So anyway, so yeah, you get all kinds of animal stuff. But well, I think we'll take a quick break, and when we come back, we'll share a few more stories. Stick around. Yeah, pretty much don't leave stuff to your animals.
Yeah, no.
I mean, you can do it but to be perfectly honest, if you are going to do it, I would do it as a lifetime transaction and not something that's created at death. It's much more difficult to contest something that you've already established during your lifetime.
Mhm.
So for example, in Texas, you can in fact create a trust for the benefit of an animal. There's a whole set of laws created just related to animal trusts. They were actually all proposed and drafted by Jerry Bayer, who's a professor out at Texas Tech. And so you can set up a trust for animals, but you would be better off going ahead and setting up that trust, funding it with some money or whatever, setting up a bank account, having all of that already in place, the money already segregated, and then at your death, you can leave the rest of your stuff however you're going to leave it. Unless you're just leaving everything, I guess, to the dog.
Yeah. Or, I've had people who've left a cash bequest in a will. I give $5,000 to my friend Susan, and then I also give the animals I have at the time of my death to my friend Susan. And I mean, I think that works. Those are separate property bequests.
Right.
And, it's not tied to the animals. So,
yeah, interestingly enough, in the case that we talked about earlier with the $50,000, it was actually $50,000 to my next door neighbor for the care of the dog. But again, this was the person thinking of the dog as essentially as a person. They were humanizing the dog. They didn't actually say that the dog went to the neighbor. They said $50,000 to the neighbor, presumably for the care of the dog, but where does the dog go? And so as this became a contested issue, one of the threats was that they would just have the dog euthanized, and then there would be nothing to care for.
Yeah.
In which case she wouldn't get the money.
Yeah, no, it was a terribly, terribly drafted will.
Yes, it was a poorly drafted will. And it really shouldn't have been done in a will anyway, as we have discussed before. We'll say this over and over.
And I presume, by the way, that Cocker Spaniel's long gone at this point.
I would think.
That was
yeah,
early on in our practice.
I would think so. But yeah, wills are they're clunky. There's better ways. Almost every time there's a better way. All right, here we go. Back live.
Have a question? Phone 903-793-1071. Now back to Aging Insight with John and Lisa.
All right, welcome back everyone to Aging Insight. As John pointed out, the last one of 2018. I'm Lisa Scholmeyer. I'm here with John Ross.
Yes,
and
you are.
Today we're just kind of lollygagging a little bit.
We are. We really didn't prepare very well for today, but we do have some fun stories.
That's right. We're still in kind of holiday mode where you don't really know what day it is and you're enjoying the short work weeks. But anyway, well, John, one of the other issues that comes up a lot that really lives in people's brains when they think about their estate planning is often I will have clients come in that they love their children.
Yeah,
They're adult children. They're pleased as punch with them. They are not big fans of perhaps the in-laws.
Yes.
Yes, the son-in-law or the daughter-in-law.
Although I will say I did have one gentleman one time, and he had three daughters, all three married. And as I was explaining, some of the common plans that we put together is to protect the kids, from things like divorce.
Yeah.
So that the inheritance can be protected in the event of a divorce. And he looked at me, and I can't on the radio. The FCC would have a problem with his language, but he said, I like the sons-in-laws better than I like the girls.
Yeah.
So
so it does go the other way as well, but probably frankly more often, I'll have a gentleman in there and he and his wife, and they'll talk about their daughter who they just love and adore, and then they will just rail against their overbearing, stubborn, jackwagon of a son-in-law that they do not like. And so one of the questions often is, if something happens to me and my, my daughter inherits and something happens to her, does that jackwagon get my stuff? I don't want a dime going to that guy. And John, a couple things on this. Number one of the internet scenarios that we saw was where a lady put in her will that her daughter would only inherit from her if she divorced her husband.
Yeah. That doesn't work.
Yeah, no, that is what we would say is something called, it's against public policy.
Yep.
To encourage divorce or require a divorce in order to claim an inheritance. So that provision, if it was drafted into the will, which I don't recall, that'd be thrown out by a judge. Daughter's going to inherit on that deal. And but again, John, as we're reading through this list, and I was like, oh, I've had that happen. Well, I had a gentleman who, again, had a big disdain for one of his sons-in-law. And so he asked if he could basically put that same thing in a will. And I said, no,
sorry.
Cannot do that.
You could put it in there, but it doesn't work.
And he said, well, all right. He's like, well, I just want to make sure that son-in-law never gets the benefit of any of my money. I mean, even if my daughter inherited it, I don't want her taking vacations or buying a vacation home or anything, and then him getting to enjoy that. I just don't want it to happen. And he said, well, what if I leave it to my daughter in trust? Can we do that? And I said, well, sure. He said, well, what can we do to make sure my son-in-law never enjoys any of the fruits of my inheritance? And I said, well, we could put it in trust, and the daughter doesn't actually get to draw anything out of the trust until her husband has passed away.
Yeah.
And because apparently there's a huge age difference between the daughter and the son-in-law. In fact, I think that was kind of some of the problem, is the son-in-law was about the same age as dad. So he just didn't appreciate the whole situation. And so we actually did draft a trust that said that, hey, daughter gets a share of dad's estate, but she doesn't get to enjoy it or spend a dime of it until her husband has passed. Now, John, we are not encouraging any murder or criminal behavior, but daughter's significantly younger than her husband, so she should be able to enjoy that inheritance
at some point.
Of course, there's no guarantee that she won't marry somebody just as unlikable,
untoward. Yes.
But we'll see. But you cannot say that the person has to be divorced to get an inheritance, so that doesn't work.
Yep. There's just some things that the law has said that are just against public policy, and they just don't work.
Yeah.
And divorce is one of them.
But yeah, if you feel strongly about something, there's probably a way to make it happen.
There's a back door. That's right.
Yeah.
All right, we're going to take our bottom of the hour news break, and when we come back, we're going to tell a few more stories. Stick around. Oh, and I apologize to you people on the Facebook, because I can turn off my microphone while I'm sniffling and coughing, but I can't turn off y'all's sound. So y'all get to listen to me sniffle and cough because of my allergies. And I did ask Amazon Alexa this morning what pollen was in the air, and she said none.
I know. There's none. It's December. There's no pollen.
Yeah, so I don't know what's jumped all over me.
Have you changed, personal care products or anything?
I haven't. Have you?
Yeah,
maybe it's yeah. But yeah, no, killing me.
Well, you might have to jump out, go get you some water or something.
Yeah, matter of fact, I think I will for a second. You can entertain the people.
Right. Yeah. So yeah, basically there's a way to do something if you really want to accomplish it. But you have to share it with your lawyer so that they understand where you're coming from and why you might be trying to accomplish something that's a little outside the box. In the case I talked about a few moments ago, where we had the man who said he didn't want his son-in-law to enjoy any of the fruits of his inheritance. He wanted to provide for the daughter, but by talking with him, I certainly understood where his motivation was coming from. And so as I was drafting his documents, I made sure to make some notes and to keep that in his confidential file. So that way, should later on that become an issue, then we could certainly explain to the court that he had his motivations. So, but you got to share that with your attorney if you want something a little outside the box.
What are you talking about?
I was just telling them if they want something different, they got to tell us.
Oh yeah, no, that's certainly right.
Don't try to do it yourself. Because you want it, if you really want it, then you want it done right. So we don't get the situation where you're providing for an animal and thousands of dollars and then it all gets challenged, or you want to make sure a son-in-law is not included. You want to do it in a way that will be least vulnerable to a challenge.
Right. Yeah. Anything is obviously contestable.
Right.
You can't prevent somebody from
people
taking.
ask me that all the time.
Yeah, you can't prevent somebody from taking $300 down to the courthouse and filing some stuff.
You just want to make it to where they don't win.
That's right.
And they feel some pain if they do lose, which they should. Many times we have included in our documents where if you contest it, will, trust, then when you lose, you forfeit any benefit you might have otherwise been entitled to.
Yep.
And I bet we can talk about some of those when we come back on the air. Some crazy stories.
Yeah, that's the no contest clause, which to some extent are a bit more of a threat than they are a real stick. But hey, sometimes threats all it takes.
Right. Yes, I like the Latin term for those no contest clause, the ad terrorem clause.
Yes.
That comes from the terror.
Yes.
Yeah. So.
Oh yeah, you and your Latin.
Hey. All right. So a couple of more.
Yeah, we still got
a minute or so.
Yeah, still got about a minute before we're back on the show. Yeah, no, there were a couple of these that on the internet that were too untoward to discuss on the radio.
On a family show, like
on a family show. That's right.
The one who left money to the elderly gentleman that left money to the stripper that visited him in his old age.
Yeah.
And by stripper, I mean prostitute.
Yeah, I think
that's really more what
it was. Prostitute. Yeah.
But he left some money in his safety deposit box and with a will to give her the money. And he also left some photographs of her, some very revealing photographs, so that his lawyer could find the young lady.
That's right. All right, here we go. In 5 seconds.
Have a question? Phone 903-793-1071. Now back to Aging Insight with John and Lisa.
Well, welcome back to Aging Insight, everybody. This is your host, John Ross, here in the studio with Lisa Schulmeyer. And today you're listening to a couple of estate planning attorneys who have done it's thousands of estate plans.
I would say so at this point.
And when you deal with that many people over that long a period of time, you're going to get some interesting stuff along the way. And we saw an article on the internet, and it just kind of spurred us to make this the topic for today of just some interesting stuff.
Well, and I guess we have people that they have very specific burial wishes. They want to be, buried with their Dallas Cowboys socks on, that kind of thing.
Yeah, one of the ones on this internet thing was I guess it was a young serviceman, airman, who was doing a will before a deployment, and he had requested to be buried in blue jeans and a Chris Jericho T-shirt and his replica WWE Championship belt.
Yeah, so for our listeners who may not be familiar with Chris Jericho,
all of our listeners know wrestling.
He's a wrestler.
That's right.
He's a wrestler, not on like Mid-South wrestling that I used to watch as a kid, but I mean like the big stuff they do now, the fake but fun kind of stuff.
That's right.
But John, kind of thinking about the crazy funeral request, I have something in mind, but it looks like we have a phone call.
We do have a caller. Let's see if we can get them on the line here. All right, you're on Aging Insight. Can you hear us? Oops, I may have done something wrong. All right, now you're on Aging Insight. Can you hear us? All right.
Yes. Well, then we already had provisions built in the trust that if any of the beneficiaries of the trust died, then their share were distributed to the other named beneficiary. So basically, her siblings would get her share, and her husband wouldn't get it. So yeah, and that's pretty typical in a lot of our estate planning, because people, unlike John's client who liked his sons-in-laws better than he liked his own daughters, most people want to be sure that a spouse doesn't get their money if their child dies, because as we explain all the time, you don't want your grandchildren's other parent spending your money on their new companion instead of it going to your grandchildren. So that's definitely something we think about quite a bit. So
all right. Well, thank you for that. And
that comes up all the time, actually. But John, we were the deal with the different requests for burial, things like that. Well, if you think about it, the President Bush's funeral that just occurred, first part of December. Of course, we have a couple of kids down at Texas A&M, and so they, as George Bush, President Bush was buried there at his library, which is located at Texas A&M in College Station, Texas. And I watched part of it, and then as the train came into College Station, they removed the casket from the train. They stood on the platform. They played "Hail to the Chief." And that was followed directly by the Aggie War Hymn.
Yep.
And of course, President Bush had planned every detail of his service, apparently many years ago, because of course he was in his 90s, and nobody knows how long we have. So that particular, that was something that he wanted. He wanted the Aggie War Hymn played as he disembarked in College Station.
Yeah.
And so.
And you can do that. In fact, you can go with your burial instructions as far as you would like to go.
As you have had.
As I have had. I had one client in particular who it took me several typed written pages to describe all of the various things that were going to happen. And as part of that, we ended up needing to set aside about $150,000.
Yeah, for her wishes to be carried out.
To make those wishes carried out, and this involved airplane as well as car travel for a number of individuals, all from different parts of the country, all to arrive in one particular part of the country. Hike, souvenirs, all kinds of good stuff.
Yeah, so be very that and if that gives you pleasure, joy to think about, when you're gone, that your families and friends will be doing things that you've provided for them to do. As a general rule, it's fine. Now, I did see on one of the internet stories, John, where one testator wanted his family to basically engage in a cross-country race in
Ah.
order to claim his Chiweenie dog and the requisite funds that went again to care for the Chiweenie. So here we are back again with animals. But in that case, the heirs challenged the requirement to conduct a cross-country race, and the court agreed and actually threw that out and said that, I'm sure the language in the will was all wonky, but the judge threw it out and said that, you can't make people engage in a unsafe. I don't know if it was like a cannonball run style race.
I don't know, but now I kind of want to put in my will that they have to get a 18-wheeler full of Coors beer from Texarkana to Atlanta, Georgia.
Well, and I think in your will, being where you live and everything, that I don't know.
It might be fun.
You could coincide it with our annual bandit run we have here.
Yeah.
So, anyway. So
I mean, as long as you're not breaking the law, generally speaking, you can put excuse me, you can put restrictions and stuff on how you want things. Also in the article, there was one where the person was not going to receive their share unless they went to the dentist.
Right. Yeah. The one, it was a lady, and I guess she had 2 sons.
Yep.
And in the will, she said, I'm going to leave everything to them. However, before they get anything, son number 1 has to go to the dentist to get his teeth fixed, and son number 2 has to lose 70 pounds.
Yeah.
I'm like, wow, that mom is, she's momming it from the grave right there.
I'm telling you. But, I think both of those would probably be enforceable provisions.
Yeah.
Now, you would get into some interpretation, does how long do they
have to get their teeth fixed?
How long do they have to get the fixed? And it didn't say get their teeth fixed. It just said go to the dentist, and so what does that mean? Does that just mean walk inside, say hi to everybody, and walk out?
Yeah.
Does that mean actually have a consultation, or does it mean actually do the treatment that is requested? So, the problem with, and that's one of the issues with doing things that are kind of out of the ordinary, is the more out of the ordinary it is, the more specific you have to be, and the more specific you are, the more risk that unintended consequences pop up.
Or that you're back in court, cha-ching,
And
needing some interpretation.
Yep.
So,
but you can try to seem pretty reasonable and it still blow up in your face.
Yeah.
One of the stories on here was about 2 brothers and a sister who as they got down to the very last of dividing everything, the estate came out 2 pennies
unequal. Yeah.
You got 3 people and 2 cents.
I'm the fact that they almost came to blows over 2 cents. If you're the lawyer, I think I'll pull a penny out of my change purse and hand it over.
Well, and you say that, one of my very first cases when I was a baby lawyer was fighting over 2 free burial plots.
So a huge economic investment.
Yes.
Huge.
And a $400 headstone.
Okay, so the 2 free burial plots and a $400 headstone.
Yep. And the case had actually gone on for several weeks, with me representing one side, the other attorney representing the other side. We finally agreed that my clients would get the burial plots, and that the other person who it was their headstone, that they would take the headstone. The problem was it was going to cost $100
to rehome the headstone.
To rehome the headstone, and my client was unwilling to pay that, and the other side was unwilling to pay that, and that case actually resolved itself when the attorney for the other side wrote a personal check for $100 to my clients, just to be done with.
Just to be done.
Case.
Hey. There you go. So sometimes being stubborn pays off.
Yeah. And the lawyer was at this point. He was saying, it's costing me more money to keep working on this case than it is to just settle it.
But sometimes, John, it's the principle of the matter.
Yep. Sometimes it's just the principle. All right, we're going to take one more break, and when we come back, we'll finish up with a few others, if I can get it to work. Yeah. No, that. that has remained. I mean, that's been coming on 15 years, and it's still fun to talk about because it was such a dumb case over nothing. And again, 2 free burial plots and a $400 headstone, and I know I got paid a couple of $1,000
Right.
on the deal. Unfortunately, the attorney on the other side, this was a
Family friend.
a family friend,
Yeah.
and not even his family friend, but a friend of his parents. And his parents had asked him to handle this, so he was not getting paid at all.
Right. So yeah, he was losing money every minute he spent dealing with that case.
Yeah, so I kind of, I understood his position of writing a personal check and just being done with that one. Yeah. Yeah. No, the kind of the backstory on that was my client's a gentleman, and he had had a heart attack, and he had lived from it, but it got him thinking about doing some, getting his affairs in order, so to speak. And one of those was to go out and check on the burial plots. And he had kind of a family plot, and his mom and his dad and maybe a brother or an uncle or something. And then he had gotten these other 2. He had gotten them years and years ago and just never really thought about it. But anyway, so he and his current wife went out to go check these out. And sitting at the head of his 2 free burial plots was his ex-wife and her husband's name on a headstone
that they had put out there.
They were
still living.
But they were still alive. They're not buried there. I guess they just thought maybe they would get buried there at some point. And apparently, in looking back in all the research and everything, they had gotten divorced, but the one asset that had not been specifically addressed in their divorce decree from a decade before were 2 free burial plots. So everybody thought they owned them. Now, why? And I again,
that's a whole other issue.
I mean, it was right in the middle of all of his family.
Yeah.
So I
You know why.
That's just poking.
You know why.
That's just poking that bear is all that was. Yeah, and then not wanting to drop the $100 to move the headstone. We got about 20 seconds. I may have to have some hot tea after this or something.
Or a hot toddy.
Yeah, or a hot toddy. But
that's what we should do. We should have our watchers, listeners, give us their best hot toddy recipes.
Yeah.
Start with bourbon.
Yes, start with bourbon.
I think you could end with bourbon too.
Here we go.
Have a question? Phone 903-793-1071. Now back to Aging Insight with John and Lisa.
All right, welcome back everyone to our final segment on today's Aging Insight. I'm Lisa Scholmeyer here with John Ross, and today we're just talking about, kind of the crazy stuff we see sometimes. And I want to hit a couple of things in our last segment today, John. One of them was one of the spark was from the story from the internet, and it had to do, again, with 3 children whose parents had left their estate to the 3 children in certain percentages.
Yes, in percentages.
And so they had their 3 children. We had a doctor, a lawyer, and a school teacher.
Yep.
And so the parents left 33% to the doctor, 33% to the lawyer, and 34% extra percent to the school teacher, because they thought, well, hey, she, it didn't say he, she, but the school teacher deserves it more because she doesn't have the same income and everything. So the whole 1%, and it doesn't say how much difference a 1% made, but it's still just 1%.
It's still 1% of something.
So in their will, instead of leaving it in equal shares, they actually left it 33%, 33%, 34%. And John, out of the 3 kids, there was a jackwagon involved who contested the will because of the extra 1% going to his sibling school teacher.
Yep.
And John, it was not the lawyer.
No.
It was the doctor brother who said, what? And actually funded a whole contest over 1%.
Yeah.
What a jackwagon.
Yeah, but man, it doesn't surprise me.
No, it doesn't surprise me one bit. And of course, the deal is doctors got the money to hire the lawyers and drag this out. Do you think school teacher has the money to blow on this kind of thing?
Yeah, of course not.
So we do often build in no contest clauses to try to maybe derail this type of thing. And I think you may have said it on the break, John, that anybody with $300 in filing fees and a want to can go to the courthouse and file a contest on a will.
Yep.
You can't prevent somebody from doing that. We have an open court system. That doesn't mean they're going to win. Just means they can go do it.
Yeah.
But in many of the trusts and wills that we prepare, we draft in a no contest clause that says, if you contest this document and you lose, then you forfeit any other benefit you might have been awarded under this document.
Yeah, you're basically treated as if you already were dead.
Yeah. So in this case, if the doctor sibling and fight with his teacher sibling lost the case, if the will had a proper no contest clause, then not only does he lose out on the extra 1/3 of 1%
Right.
that he was fighting for, he also loses out on the 33% that was already allocated to him under the will. So all I can say about that is there must have been some there's a backstory here.
Oh yeah,
There's family dynamics going on here. But so yeah, if and John, I've had clients tell me, and in my office, I had a lady come in and she had 2 daughters and a son, and she told me point blank that no matter what she did, she knew her son, who was a bully, would, when at her death or should she become incapacitated, was going to sweep in and try to bully his sisters.
Yep.
Out of inheritance, out of being mom's power of attorney, out of everything. And I'm so glad she shared that with me. Sometimes we'll get clients in that they'll just be like, oh, I have perfect children and everybody loves each other. And frankly, I try to dig a little bit.
Right.
You try to get behind, oh, everybody loves each other. When was the last time y'all all got together? But this case, the lady was very direct and said that she knew her son and she called him a bully. So we drafted paperwork that would be even more difficult for the son to try to challenge. So, you need, again, tell your attorney, tell them the bad stuff we need to know. Or maybe the stuff that's not quite so flattering.
Yeah, no, that's exactly right. I will typically draft things in different ways based on what I hear from the client.
Yeah.
And especially if I think that there is a chance, there's always a chance of conflict.
I guess it's the likelihood that we're talking about. Probability.
It's the probability, right? So the probability of contest is never 0, but it may be very small. On the other hand, it may be very large, and you've got to be the honest one there. Here recently, I was sitting in a client appointment, and I had mom there and the two kids. We were actually going over powers of attorney, and the 2 kids are there, and I said, there's different ways you can appoint agents on your power of attorney. You can kind of do an order 1, 2, 3, right? Person 1, if person 1 can't do it, then person 2. I said the second alternative is where you have an either or. I said you appoint person 1 or person 2, and either one of them can handle business. And I said, this is a very flexible option, but it requires absolute coordination and communication between those 2 people. I said, so it's about about the people, and mom said, oh well, that just sounds perfect. I mean, that would be great because the kids get along, and the kids start shaking their heads
like, nope.
They're like, no, we know we don't. And if the kids know that they don't, mom knows that they don't. So that was mom living in a little bit of a fantasy world
Right.
about the
And
relationship our children have.
yeah, that's not because trust me, when you die, the relationships don't improve. You may have a wish and a hope and a dream that your death will cause them all to come together and be a kumbaya type moment. I've never seen it happen. If there was trouble beforehand,
Right.
that trouble just is exponentially bigger afterwards.
Right. Yeah. You're not gonna make the relationship better with your death, but you can certainly make it worse. And again, not being honest about who your people are and things like that. Yeah, that's a fast way to do it. And on that same note, is doing things in your will that are just going to cause other problems like that, or fester that hate. Like, okay, so 10 years ago, you gave one of the kids $10,000. They promised to pay it back, and they never did.
Yeah, and so you leave in your will that you want kid one to pay the $10,000 back to kid two.
Right.
That's never going to happen.
No, and not only is it never going to happen, but you're dead, right? So you're out of this, and now you've pitted the two of them against one another.
I actually had a client want me to put that in the will, and I refused. And I get to a point where I recommended other alternatives, but they were just dead set that money would get paid back. And I was like, look, if you want a will like that, then maybe you should see someone else, because I know this isn't going to go well. And I'm just not going to participate in it.
Yeah, and sometimes the clients, when we do, because we will get to a point where we'll say, look, I'm not going to do that. And often they're mad at us because they think that we're, just trying to impede their wishes. But again, we know they will be dead. They're not here any longer to say, this is what I wanted. All they've done is create that fight. And I will tell you that not only are those two kids mad at each other, they're mad at us too.
Right.
Because
Yeah.
we're the ones that set it up.
Yeah.
And we are not dead. So they're looking for a living, breathing person to point the finger at. And I don't want to be that person.
Yeah. So, like in that case, in that particular case, with the lady, I suggested that, she leave extra, a $10,000 additional portion of her assets, maybe a life insurance policy, maybe a CD with, or something to that child that she that did not, quote, borrow the money during the lifetime. So that we even it out to the estate, but we didn't even it out by pitting the kids against each other.
Right. All she really needed to do was just write a $10,000 check to the
child
other
number
kid.
2. Yeah.
Right now it's even.
Yeah.
And now you can split the rest of it equally.
Well, that just always goes, John, anytime you quote loan money to family, it's really a gift.
It is a gift. And in some cases, very rarely,
they'll return that gift.
They will return that gift. That's exactly right. All right, you've reached another edition of Aging Insight. We're here at the end. We will probably be back next weekend, and
yeah.
We'll probably have some announcements coming up, because now that the first of the year is kicking up, all of our speeches.
We're going to be all over the place.
Yeah, we're going to have lots of stuff going on. So hope you keep listening to the show, and hope we see you out there in the communities when we're out there. So in the meantime, Happy New Year.
Bye-bye.
And Happy New Year to all of y'all as well.